there, you're watching BQ Prime, and this is the fine print. This week, the Supreme Court of India sealed the fate of 90,000 reassessment cases by ruling in favor of the tax department. To do that, it used a constitutional power that's rarely used by the apex court, much less in a commercial tax matter. The apex court invoked Article 142 that gives it powers to do complete justice. Besides the rare invocation of Article 142, this case is also significant for its wide ramifications. It involves thousands of reassessment notices issued by the tax department last year. Here's what happened. Last year, the Finance Act 2021 introduced stringent rules for tax officers for initiating any reassessment proceedings. For instance, a pre-notice inquiry if required, prior approval from senior officers in the department, and an opportunity to the taxpayer to oppose the reassessment, etc. This was to come into effect from April 1st, 2021. Meanwhile, to ease the administrative burden due to COVID-19, the government granted more time to the tax department to initiate reassessment proceedings in cases that would have become time-barred by March 31st last year. Relying on this, the tax department issued thousands of notices following the old procedure of reassessment. The question before the court was whether the department should have followed the old procedure since the limitation period was extended, or the new requirements should have been followed as mandated by Finance Act 2021. All high courts except one ruled in favor of the taxpayers. But this week, the Supreme Court overturned all those high court rulings. Though it didn't dispute the legal interpretation by the high courts, the apex court didn't want to leave the revenue department remediless. It concluded that the tax department made a bona fide mistake in believing that the reassessment notices could be issued under the old procedure until June 30th. So it directed that all notices issued as per old procedure should be deemed to have been issued as per Finance Act requirements. To understand the implications of the apex court's use of Article 142 in this case and the implications for taxpayers, I'm joined by Senior Advocate Arvind Datar. Mr. Datar, many thanks for joining us here on BQ Prime. Mr. Datar, I'll first get your views on the magnitude of the problem of use of Article 142 in this case by the Supreme Court.
Well, Article 142 is an article to be used very, very sparingly, and it is to be used where it's necessary to do complete justice. Sometimes what happens is that the statutory provisions are inadequate. There is some kind of a gap there, and the courts issue directions under Article 142. The classic case is the Vishaka case, where there was no law to prevent sexual harassment at the workplace. So the Supreme Court issued guidelines. That was a crime need. So the Supreme Court stepped in and said, till the new law is made, these will be the guidelines. So they have invoked 142 in rare cases where the literal interpretation of the law may lead to some difficulty. So they try to give some kind of leeway. So that's the important phrase, is complete justice. The rule is that you don't apply 142 where the statutory provisions are existing and they are clear. Merely because one interpretation goes one way and the other goes that way, that's not a ground to invoke Article 142. It's only to fill up the gaps or to fill up some kind of hardship that may be caused, that is to be invoked Article 142. And I've not seen Article 142 being invoked to save reassessment notices or any kind of tax provision at all. This is a very unique case, and it has, of course, surprised everybody that they could invoke Article 142.
Mr. Datar, if I might add, it's also surprising because, like you also sort of alluded to it, that tax statutes have to be interpreted and they have to be given a literal interpretation, not what as lawyers call a purposive interpretation. So to that extent, is the ruling also, flipping on its head the wisdom that we've got from the courts so far, that tax statutes have to be given a literal interpretation?
More than that, you see, the point is, there is an annual problem of reassessments. And we know that by March, the indiscriminate assessments are reopened, mostly to meet revenue targets. It's quite unfortunate. I mean, this for the first, we knew that reassessment notices are issued in large numbers, but 90,000 assessments were sought to be reopened. Now, it can't be that in 90,000 cases, the assessing officer was wrong originally and some income has escaped assessment. So we know of cases where reassessment notices are issued on settled principles of law, where there is no case for reassessment, the assessment is reopened and the litigation starts. So almost 30-40% of the income tax litigation is on challenging reassessment notices. And the earlier law was that if the assessing officer has reason to believe that income has escaped assessment, then he can issue the notice within 4 years, and within 6 years if there was failure to disclose material particulars. So non-disclosure would lead to a 6-year period. Otherwise, the routing period was 4 years. Now, what happened in this case is that the plea that we had been making earlier was that, look, today they just issue a cyclostyle kind of a template notice under 147. No reasons are given. Then the Supreme Court stepped in the old GK and drive shafts case and said, no, the assessee can ask, why are you reopening my assessment? If I've got income under business income, capital gains, which part has escaped assessment is never mentioned first. So the Supreme Court said, yes, assessee can say, give us reasons. The reasons are given, you can raise your objections, and then he may accept the objections or not. In 99.999% of the cases, whatever you may say is simply rejected, the reassessment is confirmed. Then you go to the court or the appeal and so on and so on. Now, 148, the new provision said that before you issue a reassessment notice, you must conduct some inquiry. You must have additional information. The additional information also is defined. It has to be in terms of a search seizure, or it has to be in terms of some CAG report or certain cases. It can't be just you change. So the reason to believe is gone. There must be some inquiry which shows that Pius Vinny's income has escaped assessment, and then you get the approval of the commissioner and go. So the entire procedure was hemmed in with safeguards to ensure that these kind of 90,000, 70,000 notices are not issued in March. So this was the very procedure for working it. And the Supreme Court says that there was a bona fide mistake in believing that they could have issued under 148A because of some extension guidelines. But with all humility, I would say that is not the case. There was a question of interpretation. The department took the view, as I know, that the new amendment has come into force on 1st April 2021. So going forward, we'll invoke the new law. But if your assessment year is prior to 2021, say 17-18 or 18-19 or 19-20, we'll apply the old law. They said 148 is a procedure, so the new law will not apply to past assessment. That's a clear stand they took, and that's how they reopened assessment. Secondly, by issuing 90,000 notices, they have never followed the mandate of 148A. They have never caused any inquiry to be done. But now, by Supreme Court terming it as a bona fide mistake, they have dispensed with the basic inquiry, and they have said that it will be deemed to have been issued under 148B and proceeded. The main difficulty is the two provisions are completely different. So you can't.
I'll come to the difficulty that it will cause taxpayers and at various levels in that sense. But I do want to go back one last time to the fact that the Supreme Court invoked these powers. There's a lot of chatter that, hey, look, what will it do to the jurisprudence on this? How do you see, going forth, this ruling and the use of these extraordinary powers that the Apex Court has impact commercial matters?
Well, I do not know whether it's going to be invoked again, but now that there's a precedent saying that you can always say bona fide mistake, you can do it. I wonder if assessees had made a bona fide mistake, whether the Supreme Court would have said, no, it's a bona fide mistake. I'll give you a fresh lease of life. I don't know if they will invoke that in that way as well. But the fact that there were 90,000 notices, I see you took a stand. The department took a stand that we are not covered by the new 148. If the remedy was by making a legislative amendment. You see, for example, in the excise and customs, there was a huge judgment of canon, and before that, one judgment saying that the DRI has no jurisdiction to issue notices. Then they amended the law, and made so this was a difficulty which should have been remedied by a legislative amendment saying that 148A will apply only for assessment is onward. This one they could have made this legislative amendment. Even after the judgment came, the Finance Act never made any such change. All it required was to say that this 148A will apply only for assessment years 21-22 onwards.
You mean to say that since last year that the high courts have been ruling in favor of taxpayers, this year's Finance Act could have made a provision?
Yes, could have made a provision.
Okay, but that was never done.
Yeah, because if the stand of the department was the new provisions apply only from assessment years 21-22 onwards, from this year onwards, not for the past period. For the past assessment years, old law applies. If that was a view, The remedy was a legislative amendment, not by invoking Article 142.
Sure. Let me now come, sir, to the ramifications of some of the directions that the court has given, and we'll try and understand for different categories of or at different stages that these reassessment proceedings are. So the 90,000 cases that were before the Supreme Court, what happens particularly to them, given that they're now assumed that they're given under Section 148A? Where do the proceedings begin from now?
You see, now there's a legal fiction that all the old notices are deemed to be under the new notice. So one has to imagine and visualize that all the notices are under 148A, and the Supreme Court says 148AB. That is, it says, presumes that an inquiry has been conducted and the notice has been issued with the approval. That is the presumption. Fortunately, the Supreme Court has been fair and said that, look, all defenses are open to you. So now assessees will have to contest the point and then take a defense of that there was no ground for reassessment and so on. I have one difficulty that today the reopening can only be on the basis of additional information, which is defined in 2-3 explanations in that. Now, if that information is not there, will the reassessment be valid? So actually, it is very difficult to say which way the litigation will go. If the idea was to save the notices, the notices were the least of the problem. The bigger problem is, are you reducing the litigation on 90,000 cases? Now you're getting into further complications of how the department and the high courts are going to reinterpret these notices. You see, because the point is, it's like, you have made the law for an earlier period on completely different grounds. It's really fitting something of like a square peg in a round hole kind of situation, where you're taking an old notice issued under the old jurisprudence and saying, no, it'll apply to the new thing when the new regime is completely different. So how this mismatch is going to play out is going to be very, very difficult to predict.
Sure. Can you articulate this difficulty for me, Mr. Datar? Because let's say and it's going to be, on the facts of each case, if the department has sent me a notice saying that we have reason to believe that for a particular assessment year in the past, your income escaped assessment, here is a reassessment notice. Now, they've not given me any reason in that reassessment notice. I'm assuming that why they think that my income has escaped assessment. Today, the Supreme Court tells me that I have a defense to ask the department that what is it that you thought in my case merited this notice. So if my defenses are sort of alive, what is the sort of procedure going to be from the tax department's point of view to then say that, look, this is why you were sent the reassessment notice? Because this is now what we have is sort of an amalgamation of the old procedure and the new procedure.
True. It's an amalgamation, and I hope it could lead to a serious mismatch. You see, because 147 has been recast, 148A has been recast. So all these sections, 147, 148, 148A, the complete scheme has been recast. The reason to believe is gone. Yeah. Now he has to reopen only on the basis of information. Information has been defined. Yeah. So now the question is, if he is going to reopen under 148A, then he must have that information, which was not the basis on which he issued the notice at all. So you're right. Actually, we are all in a quandary as to how it is going to pan out. You see, because the entire, when I say the architecture or the structure of the provisions has changed. So you're now trying to fit in a completely different set of things into a new structure. How it's going to fit, it's not going to fit properly. But the Supreme Court has said, all right. The government's argument was, we'll have to issue 90,000 fresh notices. There'll be so many appeals and so on. So they said, all right, why waste stationery? Why waste this and that? So all right, the same notice will be taken as notice under 148 and proceed on that basis. Now, if you do that, then you'll have to apply the new provisions to the old notices. If you get what I'm saying, the whole thing is going to be difficult because the old regime was different. Say it had grounds ABCD. Now it's completely PQRS. So how do you fit in PQRS to the old notice? But the Supreme Court has said all defenses are open. So now I can say that, look, if you're going to apply new 148A, then you must apply new 147, new 148. So you must apply the complete new regime, because the Supreme Court has said once you create a legal fiction, then you should not allow your mind to boggle. You must accept all the consequences of this deeming provision. Yeah. So the new 147 applies, the new 148 applies. So assessees will have a good case to say that, look, if you're coming under new 148A, 148A is only a procedure. The reason is given in 147. So if 147 is not satisfied, then my thing goes. But actually, it's really academic because in my experience, whatever you may say, all the reassessments are confirmed. That is a sad part of the situation. So I've virtually none, not a single case I've seen where the assessing officer has said, yes, I could be wrong and I'm dropping the proceedings. It's extremely rare.
Okay, so Mr. Datar, in this case, the Supreme Court has given, while it has blessed this bona fide mistake of the tax department, assessing officers have been given 30 days to provide information and material relied upon to the assessee. So you're saying once the assessing officers provide me with that information, and if I contest it, it will not hold water, and anyway the department has made up its mind that it will go forward on the reassessment.
No, I won't make such a very broad brush statement that it will not hold water. Now the assessing officer has to give reasons for his reopening. Now the question is, the reasons must fit into the new provisions of 147. So if that doesn't fit, then that will be a ground of defense. There could be some cases where the reassessment would be valid. I mean, I'm not saying that every SSC is innocent. There could be real cases of income escaping assessment. Some could have been concealments and so on. So that is quite possible. It could happen. So I can't say that every case will be knocked off or something like that. But now the SSC will have to say that if you are going to go by the new scheme, under the new scheme, my reassessment is not valid. But one more thing on the Supreme Court, to be fair, they have upheld the decision of the High Court. They said High Court was right in saying that the new provision won't apply. So some impression is given in media circles that they have set aside the High Court judgment. No, they have said the High Court is right.
But so they agreed with the legal interpretation of the High Courts, but so that the department, as they say, is not left without a recourse, they've tried to sort of do justice by invoking Article 142. Mr. Datar, I'd like your understanding on what does it mean for the pending cases before High Courts? Do High Courts proceed with those matters, or High Courts following this ruling just say that, look, the Supreme Court has said so, and all these writ petitions that are pending now are being disposed of following this Supreme Court decision? Is that how it's likely to play out?
No. I think that cases which are already pending, which have reached the High Court level, will continue to be decided by the old thing. These are only cases where the notices were issued under the old provision when the new thing has come. That's what. It's not going to affect.
No, that's the cases I mean. Not all 90,000 were before Supreme Court, who also fall in the same bracket of cases which were.
No, that Supreme Court has clarified. No, that only the Allahabad judgment was before it, but they said our ruling will apply to the other High Court. So now you have to take it as a broad brush that the new interpretation of all old notices under 147 which were issued now, which are subject matter of these 90,000 cases, they will be treated as 148 in notice. But if they were not in this 90,000 batch, suppose there were earlier notices issued under 147, I don't think that can be taken as a notice under 148A, because these notices which have just been challenged now, these notices which are impugned or challenged will be treated as a 148A notice. Other notices where SSC has filed his objections and as per the GK and Driveshot judgment, they have rejected the objection and then a writ is filed. Those will continue on the old course. Yes.
Okay, I just have one confusion. The Supreme Court has said that all reassessment notices that were issued between April 1st to till date, this ruling applies to all those notices. But if I understand correctly, the Relaxation Act extended the limitation period from March 31st to June 30th. So shouldn't it have been that only those notices which have been issued between April 1st to June 30th, as per old procedure, the tax department couldn't have been under this belief that the Finance Act procedures till date have not come into effect?
No, I find it quite difficult to believe that 90,000 officers would have believed that the new act is sort of not come into force as yet, and they can keep applying the new law. So that is not, and I agree. I've not really followed very carefully what is this extension rule, etc. If they have taken the extension rule and said because of these extension provisions, presumably because of COVID, where time was extended for various provisions, therefore we thought that we could continue under the old regime. But from what I've read, that was not the clear stand before the High Court. They were not saying that we are completely confused, we did not know because the extension notifications came and so on and so forth. They said that we can apply the old law for the past assessment period. That was the stand taken. But anyway, that's all over now. Now we'll only go by the last 6 directions or 7 directions which the Supreme Court has given. We'll have to proceed with that basis. what happened.
But I just found it curious that even if, the Supreme Court is blessing this bona fide mistake, that blessing should have been given to notices between April 1st to June 30th and not from what happened post 1st of July.
True. I agree with you. But then but then they have given, perhaps they didn't want to then bifurcate. I don't know. I was not present in court at that point of time.
Sure.
They didn't want to bifurcate it. They would have said that, look, because the other point is we do not know what are the cases in Madras, because now this judgment applies to everything. The Madras people, SSCs were never before the Supreme Court.
Yeah.
The Calcutta were never before the Supreme Court. The department said that we'll have to file 30,000 appeals. According to me, that also is not a correct thing. You don't have to file 30,000 appeals. You can file 2 test appeals from Madras or 2 test appeals from Calcutta and Bombay, wherever it is. You don't have to file all the appeals. You can say we are filing as a test case, asking the Supreme Court's ruling. But I frankly feel that if there was a bona fide mistake, if there was a misunderstanding, the extension gave them that belief. The simple thing would have been to amend the act itself.
Yeah. As a final sort of thought, Mr. Datar, some crystal gazing. How do you see things pan out on reassessment proceedings now, given that it's not like the department has got a complete, let's say, pass by for any procedures that are supposed to be followed under the Finance Act amendments? How do you see these proceedings pan out? And like you mentioned at the beginning, if the sort of attempt was to reduce the litigation, we're very far from that goal.
Yes, actually, there are 2 points I'd like to make here. To be fair, the Supreme Court has not gone into the merits of the assessment, whether the assessment reopening was valid or not. They've simply said, we'll simply treat a notice, old notice, as deemed to be a notice under the new provision. And they've left it at that. And they've said, now you start litigation. So all the challenges in the court were saying that, look, you could not have invoked the new provision. You have to go. So that has been now cleared by as far as the courts are concerned, Supreme Court is concerned. Now, individual cases will have to run the usual course. Now, what will happen is within 30 days, they have to give you the reason, they have to give the information. Then you'll have to file an order, then either assessment order will be passed, or they will say that, look, this new information which is given is not falling within the parameters of 147. So that will go on a case-to-case basis. Only thing is, if this was not there, the 90,000 cases would have either gone through the assessment route or through the writ route. Same thing will happen under the new regime. So that way, not much is changed. From the SSC's perspective, they have to only look at their own problems through a new lens. And there are new defenses in terms of law, and they have to tailor their now arguments to meet the Supreme Court directions. Yes. But more important than that, there's a pause for concern that are we misusing the reassessment proceedings? Are reassessment done extremely in a routine way without application of mind? Because when you have 90,000 assessments being reopened, it's a cause for concern. Because it will lead to potential 90. Still, you're potentially creating 90,000 cases in the litigation pipeline. Either it by the commission appeals route or the tribunal route. On the one hand, you say that there's a docket explosion and case explosion. But if you start reopening so randomly, I think the government should be very careful and say that they should not have reassessments on such a wide scale.
But that was the objective of the amendments last year, Mr. Datar, that you set out some.
That the very object of the amendment was you should not have 90,000 notices. They should be few and far between. There should be an inquiry. My parameters should be satisfied. Now, all those parameters, now you have to, in the reply, say that the parameters are not satisfied.
All right. Okay. Clearly not an end to the litigation on this front, but massive concern on the Supreme Court using its extraordinary powers under Article 142, and it's anybody's guess how that will play out in commercial cases.
Frankly, I don't think it's a case of massive concern. The Supreme Court is not going to start issuing 142 at random. So
but nobody thought, Mr. Datar, to begin with that, or I mean, like you said, right? It came as a surprise to a lot of.
Yes. Because as a tax lawyer, 142 is almost never invoked. It doesn't come because you have to go by the statute, either you go by an interpretation or you go by the thing. But I'm just telling that it's not that it's going to start becoming a rule. I don't think it will become a rule. This was an extraordinary case where there were 90,000 cases and there was a huge difficulty which the revenue tried to project, their administrative problem.
Yeah, so you make the problem so big that the Supreme Court is then forced to use its extraordinary
power. Like you're in finance, too big to fail, something like that. So it's
Right. On that note, Mr. Datar, many thanks for joining us here on BQ Prime, and thank you so much for watching.
All the best. Take care. Thank you. Bye.